All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome everyone to this initial appearance hearing. Madam Court Officer, could you please call the case?
Good morning, Your Honor. This is file KSC BC 2023-12. The Specialist Prosecutor versus Hashim Thaçi, Bashkim Smakaj, Isni Kilaj, Fadi Fazliu, and Hayreddin Kuchi.
Thank you, Madam Court Officer. Before we start, I would like to give the photographer the opportunity to take some pictures. You may proceed, Madam Photographer. It is my understanding that Mr. Smakaj doesn't want to be on a picture next to any security guard, and I therefore instruct you, when you take your picture, to take only close-up pictures of the accused. You may proceed. Thank you, Madam Photographer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of the rules that must be observed at all times in order to facilitate the smooth conduct of the proceedings. Please ensure that you activate your microphone before speaking and that you switch it off as soon as you are finished. Talk slowly and clearly, as we have interpretation from and to Albanian and Serbian. Wait 5 seconds before responding to me or a party in order to allow the interpreters to finish the interpretation. I would also like to remind you that certain information in this case is subject to confidentiality. Confidential information shall not be disclosed in open session. If any party wishes to refer to or discuss any confidential information, please request to go into private session. Now, I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office.
Thank you, Your Honor. Good morning. Josh Chaffetz on behalf of the Specialist Prosecutor's Office, and I'm joined by Kim West, the Specialist Prosecutor, who is seated behind me, and to my left, Gaia Pergolo, and behind her, Earl Sullivan from the SPF.
Now the defense, please.
Good morning. My name is Bas Martens, Specialist Counsel for Mr. Smakaj. Thank you.
Thank you, Counsel. For the record, I note that your client, Mr. Smakaj, is also present in the courtroom. And I now turn to the registry, please.
Good morning, Your Honor. Good morning, colleagues. My name is Jonas Nilsson. I'm the Deputy Registrar. I am here together with Whitney Price, Legal Counsel. Thank you.
Thank you. And last, for the record, I'm Marjorie Masselot, pretrial judge for this case. The accused is appearing today for the first time before the specialist chambers, following confirmation of the indictment against him on 29th November 2024. Mr. Smakaj, will you please stand? Could you please turn on your microphone and state your full name.
Bashkim Smakaj.
Bashkim Smakaj.
What is your date and place of birth?
Vendlindja është Klin.
Village of Kpuz, Klein, is my birthplace, and I was born on 1st of July 1976.
Citizenship, or what are you citizenships?
Shtetësinë e Kosovës.
I have a Kosovo citizenship and also Albanian citizenship.
Your current profession?
Pjesërisht i angazhuar si profesor.
Working as a professor part-time in a university in Pristina.
All right, Mr. Smakaj, before we proceed any further, I have to make sure that you can follow the proceedings in a language that you understand and speak. Can you please confirm that you understand and speak Albanian?
Po.
Yes, I do.
By this, I'm satisfied that you can follow the proceedings in Albanian, a language that you understand and speak in accordance with Rule 92 of the Rules of Procedure and Evidence. If at any moment in the course of the proceedings you are not receiving interpretation, please draw my attention to it immediately. Mr. Smakaj, you may be seated. And turn off your microphone. Yes, thank you. I will now give a short procedural history to introduce today's initial hearing. On 29th November 2024, in my capacity as pretrial judge, I partially confirmed the indictment submitted by the specialist prosecutor against Mr. Hashim Thaçi, Bashkim Smakaj, Isni Kilaj, Fadil Fazliu, and Haridin Kuchi, charging Mr. Smakaj with one count of attempt to obstruct official persons in performing official duties by participating in the common action of a group, and one count of contempt of court. I also issued an arrest warrant for Mr. Smakaj on the same day. On 5th of December 2024, the Specialist Office of the Prosecutor arrested Mr. Smakaj in Kosovo, and he was served with the arrest warrant, the confirmed indictment, and the decision on his arrest warrant translated into Albanian. On 6 December 2024, Mr. Smakaj was transferred to the detention facilities of the Kosovo Specialist Chambers in The Hague. That same day, I issued the decision setting today's date for the initial appearance. Now, allow me to recall the specific purpose of this initial appearance hearing for the benefit of Mr. Smakaj. Today's hearing, Mr. Smakaj, is not a trial. No evidence will be presented or debated, nor will the guilt or innocence of the accused be discussed or decided. The very purpose of this initial appearance hearing is regulated by Article 39(5) of the law and Rule 92 of the rules. According to these provisions, as the pretrial judge, I shall have the charges in the confirmed indictment read to the accused, confirm that the accused understands the indictment, satisfy myself that the rights of the accused, in particular his right to counsel, are respected, and inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or plead not guilty on each charge set out in the indictment. If the accused wishes to do so, he may also immediately admit guilt or plead not guilty. And finally, I shall set other dates as appropriate in performing my functions as pretrial judge. These are the matters which will be addressed in turn today during today's initial appearance. Should either party wish to discuss any other matter not expressly foreseen in the context of this initial appearance, I invite you to do so through a filing in written form. First, Mr. Smakaj, may I invite you to please stand up. And turn on your microphone. May I please ask you to confirm that you have received the confirmed indictment in a language that you understand and speak?
Po e konfirmoj.
Yes, I do confirm that.
Thank you, Mr. Smakaj. Before Madam Court Officer reads the confirmed charges against you, I wish to remind you that this is not the time to contest them, but simply to acknowledge your understanding thereof. You will have the opportunity to challenge the charges with the assistance of your counsel. I will now ask Madam Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39.5 of the law and Rule 92, 2b of the rules.
Thank you, Your Honor. 1. In the confirmed indictment, the Specialist Prosecutor charges Mr. Bashkim Smakaj with Count 12, attempting to obstruct official persons, in particular SPO prosecutors and investigators, in performing official duties by participating in the common action of a group punishable under Article 401(2) and 5 of the 2019 Kosovo Criminal Code and Article 15(2) of the law. And Count 13, contempt of court, punishable under Article 393 of the 2019 Kosovo Criminal Code and Article 15(2) of the law. 2. These offences were committed between at least 9 September and 30 October 2023. 3. In relation to these offences, there is a well-grounded suspicion that Mr. Bashkim Smakaj is criminally responsible pursuant to Article 16.3 of the law for a. Committing the offence of attempted obstruction of official persons performing official duties under Count 12, pursuant to Article 17 of the 2019 Kosovo Criminal Code. B. Assisting Mr. Thaçi in the context of the group in the commission of the offence of attempted obstruction of official persons performing official duties under Count 12, pursuant to Article 33 of the 2019 Kosovo Criminal Code. C. Assisting Mr. Thaçi in the commission of the offence of contempt of court under Count 13, pursuant to Article 33 of the 2019 Kosovo Criminal Code. And D. Agreeing to commit with Mr. Thaçi in the context of the group in the commission of the offence of attempted obstruction of official persons performing official duties under Count 12, pursuant to Article 35 of the 2019 Kosovo Criminal Code. Thank you, Your Honors.
Thank you, Madam Court Officer. Mr. Smakaj, did you understand the charges contained in the confirmed indictment as read out to you by Madam Court Officer?
Po I kuptova.
Yes, I did.
Smakaj, you may be seated. The law on the specialist chambers and the rules of procedure and evidence guarantee you a number of rights, and I will read out the most important ones, especially those relevant at this specific stage of the proceedings. You shall be presumed innocent until proven guilty beyond a reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing, subject to any measure ordered for the protection of witnesses and victims. You have the right to be informed promptly and in detail, in a language which you understand, of the nature and cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with the counsel of your own choosing. You have the right to be tried within a reasonable time. You have the right to be tried in your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to receive the free assistance of an interpreter if you cannot understand or speak the language used in the court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. And you have the right not to be detained for an unreasonable period of time prior to the opening of the case, to request review of decisions on your detention, and to appeal such decisions directly before the Court of Appeals. Mr. Smakaj, I have read to you the most important rights that you enjoy in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Yes, I do.
Okay. I also wish to inform you that according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. Representation by specialist counsel is therefore mandatory. I take note that you are represented by Counsel Martins, and I'm therefore satisfied that the accused is presently represented by counsel. I will now turn to the right of the accused to enter an immediate plea, if any, in accordance with Rule 92 of the rules. Mr. Smakaj, as already mentioned, within 30 days from today, you will be called upon to admit guilt or plead not guilty on the charges in the indictment. If you wish to do so, you may choose to immediately admit guilt or plead not guilty. I would therefore like to ask you, Mr. Smakaj, if you have had the opportunity to discuss the charges in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this time.
A mund të konsultohem me avokatin?
May I consult my counsel, please?
Counsel, do you wish a break? So we will break for 10 minutes.
Thank you
Would
very
that be
much.
sufficient? It is 11. We shall reconvene at 11:10.
All rise. All rise.
Please be seated. So we are now back in session. I note for the record that all the parties and the registry's representative are back in the courtroom. Mr. Smakaj, before the break, which you requested in order to consult with your counsel, my question was whether you had the opportunity to discuss the charges in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this time in court today. What is your response to that question, please?
Gjatë takimit që kemi pas,
During our meeting yesterday, we went through the materials that were handed over to me. However, upon the consultations we had today, I decided to use my right to enter plea within 30 days as envisaged in the legal framework, to have more time to go through all the materials necessary.
All right, thank you. So, considering that Mr. Smakaj has not entered a plea at this time, I would like to ask the parties to provide their preliminary views, if any, on the scheduling of a further hearing for the entry of a plea. I want to make it clear that this hearing should take place within 30 days from today, meaning by 7th January 2025. And I note that this falls within court recess Do you have any submissions to make in this regard, starting with the defense for Mr. Smakaj? You have the floor, counsel.
Thank you, Your Honor. Is this also the time that I could say something about the detention of my client? Because I wish to do so today.
On this second issue, you will have an opportunity, of course, to make your submission a bit later.
Okay. Talking about the status hearing, it will be next week. And the hearing that you referred to just now, I would like, if possible, that the court considers at least my agenda to be considered. Telling you also that the 7th of January will fall within also a recess, a holiday period of mine. So if possible, to have it being taken place before Christmas.
This is on the record, counsel.
Thank you.
For the specialist prosecutor.
Your Honor, we're available to be here anytime to participate in the proceedings.
Well noted too. Thank you. Further hearing for the entry of a plea will be scheduled in due course then. Now let us move to the working language of the proceedings. In the decision setting the date for today's initial appearance, I invited the parties to make oral submissions at today's hearing on the working language to be used in the present case, according to Rule 8 of the rules. Could the parties please indicate their preference for the record, starting with the specialist prosecutor?
English, Your Honor. Thank you.
This is well noted. For the defense?
I've discussed this with my client, and English also. Thank you.
Noted. Thank you. I will issue a decision on this matter in due course as well. In the decision setting the date for today's initial appearance, I also indicated that I intend to schedule the first status conference in this case, pursuant to Rule 96 of the rules, on Tuesday, 17th December 2024, at 2 o'clock. I have also invited you to provide oral submissions at today's initial appearance on whether counsel and or the accused intend to participate in the status conference in person or via video conference. You have the floor, Defense Counsel.
Thank you, Your Honor. I intend to be present in person.
And in relation to your client, have you discussed this matter?
He will also be present in person.
Well noted. Thank you. I turn now to the Specialist Prosecutor's Office. Are you available?
We'll be here, Judge.
Thank you. You will receive a scheduling order in due course that will also include the agenda. In that scheduling order, I will also provide guidelines on the requirements for attending the status conference via video conference in case, for any reason, this would have to be considered. I will now move to the next point of this agenda, which is counsel detention. In relation to Mr. Smakaj's detention, I wish to recall that based on the finding of a well-grounded suspicion that you committed the offenses that were just read to you, an arrest warrant was issued against you on 29th November 2024. Pursuant to Article 41, 6b of the law, your arrest was found necessary based on the existence of articulable grounds to believe that you are a flight risk, you may obstruct the progress of the criminal proceedings, and you may repeat said offenses. I also recall that you were served upon your arrest with my reasoned decision on request for arrest warrant and related matters, translated into Albanian together with the confirmed indictment. Now I would like to know whether the defense wishes to make submissions on this issue of detention, and I think you've already mentioned, Counsel Martins, that you wish, so I leave you the floor.
Thank you, Your Honor. I would like to do so. Yes, my client is deprived of his liberty, and as noted in the law on Article 41, no one shall be deprived of liberty save in circumstances that make that necessary. We challenge today we will be challenging the lawfulness of the arrest and the detention, but today we'll be talking about the grounds for the detention. First of all, a remark is, as we understand, but we don't know exact information, but maybe SPO could elaborate, that in the same case there's also a person who has been indicted, who is not in detention, and will be invited later to be coming on free will. And I would say, why couldn't have done the same for my client? Talking about the grounds, first of all, the risk of flight. It is known publicly in the public files, and also you could see it back in the media, that my client was confronted by a search on the 30th of September, 1 year ago, more than 1 year ago. At that time, certain items were seized, his house was searched, his car was searched, but he was not arrested at that time himself. Apparently, it wasn't deemed necessary to arrest him at that point. From that point on, as I understood from my client, this matter has not been closed because a lot of the items searched and seized were not returned to him. So he knew positively, and he knew expressively what was happening at the time, and that the case was still pending with SPO. He also knew that it was a matter of the Kosovo specialist chambers, because SPO searched his house at that time. This is relevant for the grounds of the risk of flight. He was searched more than a year ago. He did not flee his country, and he stayed living his life as he did. Talking about the grounds of obstruction of justice. As we can see in the indictment, it seems we are talking about isolated incidents, also dating back to the summer of 2023 and the fall of 2023. I haven't noted in the documents that any other acts were committed in the period thereafter. So there is, in fact, not a reason to indicate or suspect that he would continue committing the crimes he is suspected of at this time. That is relevant for the fact if he would obstruct justice. He hasn't done so, so why would he be doing that? Also, from the documents that have been provided to us, there is no indication that my client has committed an act of destroying of evidence, and as I said, no danger of repeating the offences that he has been accused of. The long periods between the accused facts being committed and now seems that the crimes were not repeated again, and there's no reason to suspect he will do so. As I told you, the SPO saw no pressing need to arrest him immediately, or at least earlier, and should indicate, in the view of the defense, in a more material way, if my client would destroy evidence, if that is a realistic fear, which we cannot go through if we go through the file, we cannot see any indication of that. The seriousness of the crime and the past conduct, the environment and conditions in which he lives, would indicate that he would commit a crime again. The defense states that there's no reason to conclude that. First of all, we're not talking about a fundamental crime for which the court has been established. The manner of the circumstances under which the crimes were allegedly committed, we don't have comments on that because we don't have an extensive file on the facts yet. But I would like to make some comments about the proportionality and the personal circumstances. SBO is completely familiar with the personal circumstances because there was a search of the car and the house more than a year ago. As my client said, he's a professor on the University of Pristina, a part-time professor. He has a known address. He has been living there for a long time. He has, since the search more than a year ago, he has stayed there. He hasn't traveled. He hasn't, other than the usual travels, he hasn't changed his fixed address since then. He is a father of 4, of which 3 children are still living at home in the age of 17, 11, and 8. So also young children is in the family. His wife has a working position. She's working full-time, and that's why my client has the care over the younger children. This care is important because there's no network that can step in at this moment. He was arrested suddenly, knowingly, without, again, unjustified that he wasn't invited to come to be tried in a case like this, in the opinion of the defense. And the children are now left without a father to care for them, while his wife has to work to provide for finances of the family. There's no network that can step in. The grandparents have deceased, except of the father of my client, as he told me, who is approximately 80 years of age. And because of this age and the distance of where he lives, about 1 hour away from the family home, cannot take over the role of caretaker of the children. There is also the financial interest that my client works to take care of the family and take care of the costs of the family. So that's also a reason, those personal circumstances and proportionality, that the defense requests the release of my client. It's not necessary to keep him in detention. There's also a request for release under conditions under the Article 41 under 12 of the law. My client is willing and able to post a bail. We're suggesting a bail of 5,000 euros to release his passport in Kosovo, report to ULEX in a certain in every term that would be deemed the court necessary, and to meet with other conditions that the court would direct him to follow. So a release under conditions is a request the defense makes at this point. Thank you, Your Honor.
Thank you, Councillor Martins. For the Specialist Prosecutor's Office.
Thank you, Your Honor. Just a few brief points. Nothing counsel has said changes or calls for any change from Your Honor's decision that's already been made regarding arrest and your findings on detention. But I do want to address just a couple of points that counsel raised for purposes of the record. One, we are in a materially different situation now that there are charges confirmed against Mr. Smakaj than we were when the search and seizure operation that counsel referred to took place. We are at an entirely different stage, and Mr. Smakaj now knows, unlike then, that he faces serious charges with multiple years of imprisonment at stake if he is convicted, which changes the calculation on the risk of flight significantly, as Your Honor has pointed out. Second, I do want to respond to the issue of this being the charges against Mr. Smakaj, and in particular, the attempted obstruction being a core crime in relation to this tribunal, and the severity of the charge, which relates to actually all three of the factors. what Mr. Smakaj is charged with is a persistent, as Your Honor pointed out, a persistent campaign to engage in obstruction of this tribunal. And in terms of the core element of that, part of the reason we're all sitting here today here is because of the climate of witness intimidation and interference that exists in Kosovo. That's a core reason why we're here. So the attempted obstruction of the case 6 and multiple witnesses in case 6 and the multiple visits Mr. Smakaj engaged with Mr. Thaçi for the express purpose of interfering with one or more witnesses is, I would argue, fundamental to the existence of this tribunal and to the law and to what we're here for today. In terms of his ability to and likelihood of obstructing both these proceedings and the other proceedings, I submit that Mr. Smakaj has already demonstrated his willingness and ability to do so, and the likelihood that he will now interfere with this now that he's charged is actually quite high, as Your Honor pointed out. So for all of these reasons and the reasons Your Honor has already put and found, and we've argued previously, Mr. Smakaj's detention is in fact necessary in this case under 41(6).
Thank you, Mr. Prosecutor. For the defense, would you like to respond?
Yes. Response only on the fact that the specialist prosecutor did not address my remarks about the risk of flight. He addressed especially the seriousness of the crime and the possibility of him to obstruct justice and maybe tamper with evidence or witnesses. But the risk of flight was not addressed, so I remain with what I've said about that. Thank you.
Well noted, counsel. Thank you. I will issue an oral decision after a short break before we conclude today's hearing. And at this point, I would like to ask the parties if there is any other issue strictly related to today's hearing that they would like to raise. To the prosecutor's office.
No, Your Honor, thank you.
Counsel Martins?
No, Your Honor. Thank you.
All right, if this is the case, it is 11:30. We will break for half an hour.
All rise. All rise.
Please be seated. We are now back in session, and I note for the record that the parties and the registry representatives are back in courtroom. I will now issue my oral ruling on Mr. Smakaj's detention. Counsel Martins, I have taken note of your request to release Mr. Smakaj on conditions. I've taken note of your submissions regarding the absence of a risk of flight, as you submit that Mr. Smakaj had already been searched 1 year ago and did not flee. You also submit that there is no risk of obstruction of the criminal proceedings, as the incidents underpinning the charges are isolated, and there is no risk that Mr. Smakaj will continue with obstruction. Moreover, the time passed between the alleged facts and today does not justify the indication that he may obstruct the proceedings. You also submit that there is no risk of commission of further crimes, considering the seriousness of the offences, the environment and conditions in which Mr. Smakaj lives. I've also taken note of your submissions on proportionality in light of the personal circumstances of Mr. Smakaj, in particular his family, professional and financial situation. I've taken note of the specialist prosecutor's position that Mr. Smakaj remain in detention as all of the requirements under Article 41(6) of the law are met. I note that the SPO underlines that the risk of flight has increased now that the charges have been confirmed, as opposed to the time when Mr. Smakaj was searched 1 year ago. I also note the Specialist Prosecutor's Office submission that the offences with which Mr. Smakaj is charged are serious in nature and reflect his demonstrated willingness to interfere. Having considered all arguments, I find that none of your arguments, defense counsel, are capable of changing my assessment that the conditions provided in Article 41(6) of the law are met, as set out in the decision on arrest warrants and related matters, filing F37, paragraphs 43 and 69 to 80. Specifically, I'm not persuaded that Mr. Smakaj is not a flight risk. In particular, since the search in 2023, the charges against him have now been confirmed, which, together with the gravity of the offences and the potential sentence, provide him with a motive to evade justice. I consider that the fact that Mr. Smakaj has rooted family ties in Kosovo only mitigates but does not diminish the risk that he may flee. As to the risk of obstruction and commission of further offences, I find that the purported isolated nature of the offences and the passage of time are insufficient to disturb the findings that are made in the decision on arrest warrant and related matters, paragraphs 74 to 79. Therefore, having considered the parties' submissions, I determine that Mr. Smakaj shall remain in detention. The reasons for your detention, Mr. Smakaj, are the same as set out in the said decision, paragraph 43 and 69 to 80, which shall be read together with the present oral ruling. Accordingly, based on the information and material underpinning said decision and in the absence of any contrary intervening information or development, I find that, first, there is a well-grounded suspicion that you are criminally responsible for the offences of which you were informed today. And second, there are articulable grounds to believe that you are a flight risk, you will obstruct the progress of the criminal proceedings, and you will repeat the criminal offences. Furthermore, neither the conditions you propose, Defence Counsel, nor any conditions I may impose on Mr. Smakaj are capable or adequate to mitigate these risks. Mr. Smakaj, I will review the reasons for your detention within 2 months or at an earlier time upon request or a change in circumstances as provided in Article 41(10) of the law and Rule 57(2) of the rules. Counsel Martin, should you wish to file submissions on the next review of detention, please do so by no later than Wednesday, 15th of January 2025. Responses and replies will follow the timeline set out in Rule 76 of the rules. Should the defense decide not to file any submissions on the aforementioned time limit, I order the Specialist Prosecutor's Office to file submissions on the next review of Mr. Smakaj's detention by no later than Tuesday, 21st of January 2025. The defense shall then respond, if it so wishes, by no later than Tuesday, 28th of January 2025. I will not entertain a reply. Lastly, Mr. Smakaj, you have the right to appeal today's ruling on your detention directly before the Court of Appeals within 10 days as provided in Article 45(2) of the law and Rules 58 and 170 of the rules. This concludes my oral hearing, and this also concludes Mr. Smakaj's initial appearance hearing. I wish to thank the parties and the registry for their attendance, and the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is now adjourned.
All rise.